4.2 Consensus Consideration. Article 114, Consideration. Canon 2201. Consideration is the offer of something possessing value given as incentive or recompense for a previous promise, which then causes the promise to become binding as a consensus if accepted. Canon 2202. Under unilateral consensus, the provision of new and fair consideration through an offer consistent with the previous terms of the contract represents a legitimate revision to the unilateral consensus instrument, unless formally and expressly challenged by one or more valid points of law consistent with these canons. Canon 2203. A party that is unable to meet their obligations as per a consensus has the fundamental right to offer fair consideration in exchange for amendment to their performance obligations, regardless if a consensus instrument claims such rights are prohibited. Canon 2204. A party that is unable to meet their obligations as per a consensus and fails to offer fair consideration in exchange for amendment to their performance obligations may be declared delinquent and therefore cede any rights of remedy. Canon 2205. Where a long-term tenant of 3 years or more is unable to meet their obligations as per a consensus and fails to offer fair consideration in exchange for amendment to their performance obligations, the tenant may be declared delinquent and forfeit their right of redemption, also known as equity of redemption. Canon 2206. Where a party under a consensus makes in good faith and gives proper notice of an offer of fair consideration in exchange for amendment to their performance obligations to the other party and the receiving party fails to reject such fair consideration in reasonable time, the consensus shall be regarded as duly amended. Canon 2207. Consistent with the statutes of a valid juridic person in accordance with these canons, a validly amended consensus through fair consideration may not be recognized unless properly recorded and acknowledged. Article 115, Question. Canon 2208. A question is a sentence or word expressed or written so as to elicit information or identify a matter requiring resolution or discussion. Canon 2209. The word question originates from the Latin questus, meaning complaint, charge, or lament. Hence, a question by its original meaning implies one or more presumptions in its delivery. Canon 2210. In formal grammar, a question requires either an answer, or by custom that any silence is interpreted as an answer in the affirmative to the proposition put forward in the question. Canon 2211. In law, all formal and valid questions pertaining to a matter must be fairly resolved before the matter can be properly concluded. Canon 2212. In law, all implied presumptions embedded within formal and valid questions stand unless rebutted. Article 116. Statement of claim. Canon 2213. A statement of claim is a formal legal complaint, also known as a cause of action, that something is true or that some performance or action is due. Canon 2214. The word claim originates from the Latin clamo/clamare, meaning to shout, cry out, proclaim, to call upon. Canon 2215. The most common form of pursuit and resolution of a claim is through the lodgment of a statement of claim via civil procedure of the relevant jurisdiction of a juridic person. Canon 2216. A statement of claim must generally present only one cause of action via the detailing of a series of alleged facts, also known as elements. The most common causes of action include, but are not limited to, physical injury, assault, battery, negligence, intentional identity/reputation injury, invasion of privacy, slander, identity theft, intentional emotional injury, fraud, and unjust enrichment. Canon 2217. Generally, the named party within a statement of claim is called to answer the complaint through formal response to admit, deny, request more information, move to dismiss on technical fault or lodge a counterclaim. Failure to answer through the prescribed form defined by statute of the juridic person is to admit the facts of the cause of action and a summary judgment may be awarded. Canon 2218. The use of private forms not recognized by statute of the juridic person having jurisdiction in response to a claim may be correctly interpreted as the absence of a valid objection and therefore a summary judgment may be awarded. Canon 2219. A counterclaim in response to a statement of claim is a wholly separate cause of action, and while it may refer to similar facts and circumstances, must be written as if the original claim did not exist. A counterclaim that references and rebuts another claim is not therefore a valid counterclaim, but an objection in the wrong form, therefore null and void. Article 117, Charge. Canon 2220. A charge is a demand for agreement to settle an account concerning an accusation pertaining to some prior encumbrance, lien, burden, obligation, or liability for payment for a service rendered or goods conveyed. Canon 2221. The word charge originates from the 13th century Latin combination of car, o, meaning flesh, and gero, meaning to carry, wear, to bring, to bear, produce, to show, or administer. Hence, the original 13th century meaning of charge produced by the Roman cult is to load the flesh, to burden the flesh. Canon 2222. All forms of charge are commercial, even if the word is used in the context of criminal matters. In terms of criminal matters, guilt is interpreted as both proof of a valid debt to the bar and the ancient method of payment to the private bar guild being gold or gold species. Canon 2223. All forms of charge in law presume the existence of four key elements being account, obligation, right of claim, and jurisdiction. I. Account charge presumes the prior existence of some commercial account connected to some corporate, trust, or estate, and 2. Obligation charge presumes a prior obligation which permits the demand of charge against an account, and 3. Right of claim charge presumes the one making the claim has the right to do so on behalf of the lawful claimant, and 4. Jurisdiction charge presumes the enforcement of any demand or administration of settlement of any charges within the jurisdiction of those making the demands. Canon 2224. If one or more of the core elements of presumption of charge, account, obligation, right of claim, or jurisdiction, are invalid, then any charge is false and therefore null and void. Article 118, Offer. Canon 2225. An offer is an invitation to consent and enter into a binding consensus communicated to another party which contains terms sufficiently definite to create an enforceable consensus if the other party accepts the invitation. Canon 2226. The word offer originates from ancient Latin offero, meaning to present, show, bring forward. Canon 2227. An offer must be first made before a consensus can lawfully be accepted. Canon 2228. Mere recommendation of an article does not bind the vendor of it. Canon 2229. As the original and true definition of judgment is to bind together the mind and person, all judgments of the court are an offer requiring consent, usually through the interpretation of absence of objection. Canon 2230. In the presence of a vocalized objection, non-consent or counter-offer, a judgment shall have no legal or lawful effect, regardless of what a judge or magistrate may claim. Upon appeal, such judgment must be rendered invalid and reparations made. Canon 2231. In the presence of a vocalized objection, non-consent or counter-offer to a judgment, by law an alternative judgment must be offered by the judge or magistrate for a consensus and therefore the judgment to be valid. Article 119, Bid. Canon 2232. Bidding is the process of reaching a consensus through the process of offering a good, service or security for sale and then securing its sale to the highest bidder, usually through a formal process, such as an auction. Bidding is in effect the formalization of the ancient art of haggling. Canon 2233. The word auction is derived from the Latin word auctiones, meaning a sale of slaves through a bidding process. The special register of slaves or tabulae was even called an auctionarius for such an event. The sale of bonds of slavery in honor of this ancient Roman process is continued today in Roman courts with the use of block and gavel. Canon 2234. There are generally recognized to be four common types of auction, being open ascending price, open descending price, first price, sealed bid and sealed bid, second price. Open ascending price auction, also known as an English auction, is when participants bid openly against each other with each successive accepted bid higher than the previous, and 2. Open descending price auction, also known as a Dutch auction, is when the auctioneer announces the highest asking price, which is gradually lowered until some participant is willing to accept the auctioneer's price, and 3. First price sealed bid auction is when all bidders simultaneously submit sealed bids and the highest secret bid wins, and 4. Sealed bid second price auction is when all bidders simultaneously submit sealed bids and the second highest secret bid wins, and Canon 2235. As Roman courts seek to perfect the sale of bonds against the accused, the judgment also represents the opening highest price of an open descending price auction or Dutch auction, with the judge or magistrate as auctioneer. Unless the accused makes a lower legitimate bid, the original highest bid, sentence, is deemed the sale price and the accused is assumed to have consented by the time the judge strikes the block with their gavel. Canon 2236. As the judgment of a Roman court is also a Dutch auction, the judge and magistrate must give adequate time for the accused or convicted to vocally lodge a competing lower bid. Should the judge or magistrate terminate the auction by striking the block prematurely and before the accused or convicted has finished speaking, then under appeal the judgment should be ruled invalid. Article 120, Gift. Canon 2237. A gift is a voluntary present, without charge. Canon 2238. The word gift itself is an ancient Khazarian word found in a number of related languages meaning poison and venom. Canon 2239. The method of gift is one of three traditional ways under the Roman cult in which property and rights may be lawfully conveyed via deed in honor of the ancient underlying properties of financial instruments as indulgences. Article 121, Grant. Canon 2240. A grant is a conditional gift or conveyance of property or rights, by consent or permission of some authority. Canon 2241. The word grant is a 9th century creation under Anglo-Saxon law of the Latin word gratia, meaning grace, favor, kindness, influence, regard. Hence, a grant has always implied a grace, favor or kindness from some higher authority to a person in lower authority for the conditional use of some property or rights. Canon 2242. Grant is the proper term used within a valid deed when referring to the first conveyance of real property. A further example is an act evidenced by letters patent under the Great Seal of an estate, granting something from a general executor to a beneficiary. Canon 2243. A grant made by an instrument in writing under seal is irrevocable unless an express power of Revocation is reserved. Article 122, Conveyance. Canon 2244. Conveyance is a term used to define the physical process of transfer and delivery of certain property or rights from one party to another, as well as any instrument which serves a similar purpose in the transfer of property or rights from one party to another. Canon 2245. The term conveyance appeared in the English language from the late 16th from the term convey, derived from two Latin words com meaning together, with, and via meaning way or road, and the suffix ans meaning state, quality, process of. Canon 2246. In terms of the meaning of conveyance as an instrument, conveyance includes every instrument in writing under seal by which any estate or interest in real estate is created, aliened, mortgaged or assigned, or by which the title to any real estate may be effected in law or equity except will and testaments, leases of less than 3 years or executor contracts for the sale or purchase of lands. Canon 2247. In terms of the meaning of conveyance as a physical process, there are five forms being absolute, conditional, primary, secondary, and voluntary. Absolute conveyance is one by which the right or property in a thing is transferred free of any condition or qualification by which it might be defeated or changed, and 2. Conditional conveyance is one by which the right or property in a thing is transferred under conditions by which it might be changed or revoked, such as a standard mortgage, and 3. Primary conveyance is the first by which the benefit or estate arises, such as by gift, grant, feoffment, lease, exchange, and partition, and 4. Secondary conveyance is the term used for all subsequent conveyances presupposing a primary conveyance and for the purpose to enlarge, confirm, alter, restrain, restore, or transfer the interest granted by the original conveyance, and voluntary conveyance is one without valuable consideration such as a deed or settlement in favor of a spouse or offspring. Article 123, Necessity. Canon 2248. Necessity is the unavoidable requirement of a party to consent, act or perform in a manner that they would not otherwise do if not for the presence of some clear need, threat, coercion, danger, or risk. Hence, any oath, vow, sign or seal given under necessity has no legal validity or value. Canon 2249. Compliance to an order or demand under necessity can never be lawfully claimed as consent, providing the party makes clear such compliance is under duress either vocally as well as including such words with any sign or seal. Canon 2250. Contrary to any statutes, rules, or orders that are in conflict with this canon, when a man or woman professes that they complied to some order, demand, or act out of necessity and under duress, then any oath, vow, sign, or seal given is automatically null and void within 7 years of such an act or acts of necessity. Canon 2251. Excluding alleged serious offenses involving violence, sexual abuse, or dishonesty, no man or woman may be accused of any offense when professing they undertake or have complied with an act under duress as a necessity. Canon 2252. When a man or woman pronounces in advance that they shall comply to some order, demand, bond, or promise out of necessity under duress, then the subsequent execution of such an order, demand, bond or promise constitutes a clear, proven, and serious act of fraud by the executor or their appointed trustees issuing such an instrument. 4.3 Consensus Obligation. Article 124, Obligation. Canon 2253. An obligation is something, as a formal consensus, a promise, or the demands of conscience or custom, that obligates one to a course of action through some consensus, instrument, product or transaction. Canon 2254. Obligations agreed in good faith, free from fraud and duress, are to be met. Canon 2255. When fraud by one party is proven to exist, the other parties are released from all obligation. Canon 2256. Failure to perform an obligation without legal excuse gives the other party the right to seek legal remedy. Canon 2257. No one may be obligated to perform an impossibility. Canon 2258. No one may be obligated to perform a fraud or other offense. Canon 2259. No one may be obligated to perform an act against their conscience or moral faith. Canon 2260. The failure to perform one or more obligations of a formal consensus may be grounds for the extinction of a consensus, or punitive acts as stipulated within the consensus instrument. Article 125, Oath. Canon 2261. An oath is a public invocation and affirmation of truth or acceptance of one or more rights in trust. A testimony under a valid oath is the strongest form of testimonial evidence, and 2. A person cannot be invested into an office, nor hold any authority or power without a properly pronounced oath and vow. Canon 2262. The word oath originates from the Quilian, Holly, of Ireland in the 3rd/4th millennium BCE and the ancient Irish word oath meaning sacred surety or bond by words. Hence the ancient proverb of the Celts, "My word is my bond," in reference to the ancient honor to the original and true meaning of oath. The various claims that the word oath comes from Anglo-Saxon invented term ao, or Dutch term eed or German eid or Latin uter are all deliberately false, deceptive, and misleading. Attempts to cloud the overwhelming linguistic evidence throughout ancient Irish, Scottish and Celtic languages of the presence of the word oath and its original meaning, and 2. The original meaning of oath is a solemn public appeal to the divine creator as witness that some testimony be true appears to have survived within Celtic culture and Anglo-Irish and Scottish history to at least the early 16th century, and 3. The deliberately false, deceptive, and misleading creation of the compound word swear from sui so, and we're, occurred no earlier than the second half of the 16th century and prior to the fabrication of the false scripture of Matthew 5:33-37 against swearing, and falsely connecting the word swear to the process of oaths, and 4. The appearance of the profane, sacrilegious, and necromantic definition attached to oaths, being a careless use of the name of God or Christ or out of something sacred, or profane. Swearing appears at the same time that the words swear and sworn appear in English statute and the extraordinary statute of Henry VIII in 1541, 33 Hen 8.c.27, that claimed the power to nullify and void oaths using the sacrilegious, anti-Christian, and heretical claim that the monarch of England be supreme and godlike, and thereafter, the reference to oaths within English statute is almost always connected with inserting the words swear and sworn to reinforce the impression that an oath was to be made through some ritual of swearing, thus in contradiction to the false Christian scriptures commissioned by agents of the Roman cult and necromancers in the late 16th century, and 6. However, toward the end of the 18th century, the function of oaths and their necessary importance in forming proper trusts, office and authority was reintroduced into British law through the Oaths Act, 15Go3c.39, that now introduced the notion of administrative oaths through justices of the peace and therefore the bizarre notion of administrative trusts, whether or not a person properly pronounced an oath or not, and 7. The false, absurd, and morally repugnant notion of administrative oaths, as the justification for creating administrative trusts as if valid trusts, was further refined through subsequent statutes in 1838, 1 and 2 Vic C 105, 1888, 51 and 52 Vic C 46, 1909, 9 EDW 7 C 39, and 1961, 9 and 10 Elise 2 C 21. However, in all cases the notion that an administrative act of a justice of the peace is equivalent to a valid public pronouncement of an oath is unsustainable in law, and 8. In direct contrast and as evidence as to the continued knowledge as to the legal effect of a valid oath, the introduction of various oaths acts to ensure that specific persons are properly invested under a valid oath, compared to the rest of the population, is proof of the power of valid oaths, namely the Coronation Oath Act 1567, c.8, and Coronation Oath Act 1688. Canon 2263. As the concepts of public invocation and affirmation of truth and the public invocation and acceptance of one or more rights in trust are fundamental principles of the rule of law, the existence of such concepts of law in civilized society prior to the wholesale corruption of the Western mind by the necromancers of the Roman cult from the 16th century onward, is well documented. The earliest form of oath and the word oath itself literally originates from the Quilian Holly of Ireland and the 3rd/4th millennium BCE Irish word oath meaning sacred surety or bond. By words through the ritual of seal meaning my words bind, bond, me, to some promise/oath, and 2. The ancient Greek form of oath central to the rule of law of the Alexandrian Empire was the word omnio, omicron mu nu omega, meaning to pronounce, take an oath to divine, derived, law, and 3. The Roman form of oath central to the rule of law of the Roman Empire called in Latin iro, meaning I take an oath upon the law, in the name of the divine, and 4. The Carolingian form of oath revived in the 8th century CE was called commito from the Latin of the same name meaning I bind myself according to the law and was the central element of the ritual of fealty between lord and vassal under sacred law. Canon 2264. The deliberately false, deceptive, misleading and morally repugnant words of swear and sworn are from the 16th century and have nothing to do with the valid process of making an oath, but the opposite. Swear is shorthand for forswear and means properly from its inception to renounce or deny something, or to commit perjury. Hence, when one swears, or forswears, one literally commits an act of perjury, falsity, and profanity in making a false oath against heaven. In other words, to swear is to self-curse, and 2. The word swear was created from the compounding of two words in the 16th century being sue from sue, so meaning female pig and to petition, entreat, submit to plead and the term wear, from weir, meaning to fence or enclose, to impede the flow, of a river, by tradition for the purpose of fishing, and 3. The word sworn as the past tense of swear was created from the term warn, from warn, meaning to surrender, capitulate, from exhaustion. Canon 2265. By the custom and tradition throughout the history of law, an oath can only be valid if the following criteria exist. The one making the oath comes with good intention, good character, and good conscience. And 2. The one making the oath has the right and proper authority to make such an oath, and 3. At least one other person is present and prepared to witness the oath and testify to such a fact, and 4. The candidate raises his right hand with a flat palm so that the face of the open palm can be clearly seen by all witnesses during the pronunciation of the oath, whilst his left covers his heart, as the symbol and source of truth of the spoken words, and that the pronunciation of the oath never uses language of profanity such as swear, and 6. That some written memorandum, to the event exists, signed by the one making the oath and a different personality as witness. Canon 2266. The claim that an oath is only valid when the one making it is holding an external object of claimed sacred significance is a historic falsity and is a reference to the ancient pagan Roman tradition of holding some relic of an ancestor as a means of creating a negative spiritual surety against breaking such an oath. No valid oath, or Christian oath or true Catholic or religious oath requires the one making such an oath to place their hand on some object, such as a Bible, and 2. As the text of the book known as the Bible is clearly contradictory to all known civilized rule of law, particularly in the proper formation of office, oaths, vows and authority, any person holding or placing their hand on a Bible, by the words within the Bible itself, invalidates any such claimed oath or vow. Canon 2267. No one should be heard within a valid form of law unless they have previously pronounced a valid oath for the matter at hand, without reference to the profane terms of swear or sworn or touching such sacrilegious and false objects such as a Bible. Furthermore, no testimony in written or oral form is valid unless a valid oath has previously been pronounced and witnessed. An oath extorted by malice, force, or grave fear is null. Canon 2268. In the absence of a valid and proper oath, no person claiming possession, or occupation, or investiture or ownership of an office holds any authority or power whatsoever, and any and all actions made by such a person are completely without validity in law, whether or not the parties present did consent or decline. Article 126, Vow. Canon 2269. A vow is a public invocation and promise to perform one or more obligations associated with one or more rights and trust of an oath. By its nature, a valid vow is the sole source of authority of the one who makes it, and in the absence of a valid vow a person holds no authority or power. Thus, a person cannot be properly invested into an office without both a proper oath and vow. Canon 2270. The word vow originates from the ancient Greek word vow, kuf, meaning promise, and the 3rd century Christian word charis, caparoeta, meaning solemn binding promise, pledge, or invocation, or religious vows. The various claims that the word vow comes from Anglaise, Old French, of the Carolingians as vot is an absurdity and morally repugnant as the true term adopted by the Carolingians in the formation of the Catholic Church from the 8th century CE was voti/votum, vote, meaning public promise, dedication, sacred vow, and 2. The original meaning of vow is a solemn public appeal to the divine creator as witness to some promise to perform one or more obligations associated with one or more rights in trust. Appears to have been depreciated when Constantine formed the ecclesiastical, moral, and lawful framework of Christianity. Instead, the term charis, caparoeta, meaning solemn binding promise, pledge or invocation, or religious vows was adopted as the formal Christian term for vow. Hence charity, and 3. To deliberately confuse, depreciate, and usurp the Christian notion of charity as a solemn religious vow. By the 16th century CE, the necromancers of the Roman cult restored the use of the word vow in statute and ecclesiastical constitutions. The term charity was then completely corrupted to infer the false meaning of Christian love, love of God, Satan, Lucifer, devil, pretending to be God, and the benevolence to others, giving of possessions to those in need. And 4. By the late 17th century, the Catholic ecclesiastical term for vow being votum, vote, was deliberately corrupted and depreciated to be a secular act of choice and participation in matters of administration of a body politic, and the use of the term vow now rests almost completely within the concept of ecclesiastical Ritual associated with the claimed formation of ecclesiastical personalities such as priests, nuns, and other religious offices. However, in the absence of competent acknowledgement of the first part, a valid oath, in failing to identify or name or accept any rites, the function of promising to perform a vow is redundant. Canon 2271. As the concept of public invocation and promise to perform one or more obligations associated with one or more rights in trust of an oath is a fundamental principle of forming any valid office and possessing any valid authority and power under the rule of law. The existence of such a concept of law in civilized society prior to the wholesale corruption of the Western mind by the necromancers of the Roman cult from the 16th century CE onward, is well documented. The earliest forms of vows in civilized law originates from the Quilian, Holly, of Ireland and the 3rd/4th millennium BCE Irish word plead meaning promise and the word guide meaning solemn binding promise, pledge, prayer, and 2. The ancient Greeks used the term vow, kuf, meaning promise and a solemn binding promise, pledge, prayer similar to the Celts, and 3. Imperial Roman law, prior to the complete destruction of Rome from 313 CE by Constantine, used the term obligatio, obligation, meaning binding, debt, liability, or death pledge as a negative form of vow whereby a person effectively created a negative spiritual security or unfulfilled curse against themselves in the event that they broke their promise, and 4. Under the formation of Christianity from 314 CE onward, the term charis, caparoeta, charity, was adopted meaning solemn binding promise, pledge, prayer, religious vows, and the Carolingians in the 8th century CE revived the ancient Holy language of law with Latin to define the word promissa, from where the word promise is derived, meaning promise, and pligo, from where the words plea and pledge are sourced, to now mean solemn promise, pledge, prayer, religious vows connected to the public act of voti/votum, vote, meaning promise, dedication, sacred vow. Canon 2272. A vow made by oration in the presence of others is always superior to a written vow. A vow made in secret or privately has no effect and is void from the beginning by virtue of not being made in public. Canon 2273. A vow made free from coercion, fear, or deliberate deception must be fulfilled. A vow made out of grave and unjust fear or malice, or ignorance is null by the law itself. Canon 2274. A vow ceases by the lapse of the time designated to fulfill the obligation, or by a substantial change of the matter promised, or by the absence of a condition that the vow depends upon, or by the absence of the purpose of the vow, or by dispensation, or by commutation. Canon 2275. No temporal force or action or an inferior person, or Roman person can dispense or commute solemn vows of a superior person. Canon 2276. Only a supreme person can dispense or commute solemn vows of superior persons in all lesser persons. Only a superior person can dispense or commute solemn vows of ordinary persons in all lesser persons. Only an ordinary person can dispense or commute solemn vows of curator persons and all lesser persons. Inferior persons and Roman persons have no rights nor powers to dispense or commute solemn vows. Canon 2277. As inferior persons or Roman persons have no power or authority to dispense or commute solemn vows, when any such vow is breached or any action is made to claim that dispensation or commutation is given, then such an action is a direct injury to the divine Creator and all law. Therefore, any such liability and penalty due immediately befalls the person who breached their solemn vow. Canon 2278. In the absence of a valid and proper vow associated with a valid and proper oath, no person claiming possession, or occupation, or investiture or ownership of an office holds any authority or power whatsoever, and any and all actions made by such a person are completely without validity in law, whether or not the parties present did consent or decline.